What is stepped up basis? Why does it matter so much? Is it really an important part of my estate plan? These are questions that we deal with all the time in farm succession and estate planning, and it's important that you understand how it impacts your estate plan. Welcome to Farm Lawyer. I'm Jason Wagner, and I help farmers, landowners, and rural families protect their land, secure their legacy, and plan for the future. Whether it's creating an estate plan, setting up your farm succession plan, or structuring your business, I'm here to guide you through the decisions that matter most. If you're ready to plan smarter and protect what you've built, let's get started. Now, don't get me wrong. Stepped up basis is a huge tax advantage in the right circumstances. However, it's not always the thing that should drive the estate plan. So let's get into what is stepped up basis. Well, stepped up basis, it's normally a step up, I should clarify. Sometimes it can be a step down. What it is it's just a basis resetting that occurs when a person dies. So if the land, the machinery, the grain, the livestock, it doesn't matter, Ford stock, whatever it is that you own when you die, if it's included in your estate, then that gets a basis reset equal to the fair market value of what it is when you die. So a lot of farmland out there has low basis. Why? Well, one reason is the doubling of the price of farmland in a very short period of time. You know, we're looking at some appraisal statistics the other day. In 2020, in this area, average price of farmland would maybe be $6,500 an acre. Well, now the 2024 average values are coming in at $10,000 to $11,000 an acre, and there's definitely been prices higher than that. And we've gone from peaks of, say, 12 years ago, it was at $10,000 an acre, then it dropped down. I mean, at one point, you could pick up land for $4,500, $5,000 an acre, and I've had clients tell me at that time that were offered to buy at $7,500, they thought it was way too much. But, pandemic money came out. We had some very good years, low interest rates. Input costs weren't going up yet. So there was a lot of cash out there. And in the meantime, of course, rents went up, land prices went up. We're not quite in that same environment anymore. But land prices seem to be sticking up there and stabilizing up at that over 10,000 or at around 10,000 an acre. I've seen some drop, but whatever, let's work with that number. So now let's backtrack. All right, if I'm a farmer and I paid $3,000 an acre, which, that wouldn't even be that long ago, and now it's worth $10,000 an acre, everything in between is going to be a capital gain. So I paid $3,000, that's my input into it, that's my capital cost. I've held it, I've paid down my mortgage, it keeps going up in value. Boom, now it's up here at $10,000 an acre. If I turn around and sell that, I'm going to have a capital gain of $7,000 an acre. Everything in between, right? So if it's gone from 3 to 10, I have a $7,000 capital gain, which I will never realize unless I sell it. We don't have a tax on capital gains or unrealized capital gains at death. We only have an estate tax we have to worry about. So if I never sell that, I'm never going to pay any capital gains tax on that difference of $10,000 to $3,000. Now let's say that I die with it, and maybe the value of the farm is just under $3 million. Let's take 300 acres, 10,000 an acre, $3 million. We already know that we're not going to have an estate tax because the value of the estate's $3 million or less, and that's Minnesota's estate tax exemption. It's also well below our federal estate tax exemption of $13.99 million for couples or individuals dying in 2025. So I've allowed this farm now to pass completely estate tax free into the hands of my heirs or my trust. And they now get to reset that basis. So remember, mine was 3, but now the value is 10. So we get to reset it. So we're going to go get an appraisal. That appraiser is going to tell us what they think the value is, which is all an appraisal is, of course. It's just an educated guess. That's going to push that value up, and now it's $10,000 an acre. My heirs now have $10,000 an acre basis in that land. If they choose to hold on to it, any future appreciation is going to be capital gains. It depreciates to $12,000, $15,000 an acre someday in the future. And their basis, if they sell it, is always going to be at that 10. Now, if they choose to sell it right away, they will not have any capital gains tax at all. Why? Because of that basis step up, that basis resetting. If it's $10,000 an acre the day I die, and they turn around and sell it for $10,000 an acre, there's no capital gains, which means there's no capital gains tax. That is a hugely beneficial option out there if the likelihood is that our heirs are going to want stepped up basis, and they would likely sell it because we've escaped estate taxation and now we've escaped capital gains tax as well. So that is a hugely powerful tool for farm succession planning when it's maybe more likely that our heirs are going to sell the property. But when we have a farm successor, that is not the driving factor. I will have farm successor after farm successor say to me, stepped up basis would be nice, but I don't ever plan to sell this. If I do sell this, it's going to be to my farm successor. So what do we care about stepped up basis in that instance? To me, it's a tool in the toolbox. It is not our compass or our guiding light. And too often, we hear from clients or even I've heard from another attorney in the last week that they're not really big into gifting, or the client's been told they shouldn't gift because they need to get the stepped up basis. Need to for who? Who? The farming heir who isn't planning on selling it? They don't care. Put your money where your mouth is. If you say that you don't care about stepped up basis, then let's go ahead and gift it. That's just the thing, is if we say that stepped up basis is the most important thing to us, we're taking a hugely important tool out of our toolbox that is gifting. So why does that matter? If I take that same $3,000 an acre land and gift it to my farming heir, they're going to have what's called a carryover basis, which means that just their basis is whatever my basis is. It's even keel. So again, they're not getting the stepped up basis. And if they ever sell it, they're going to have the same tax problem that I would have. But what are we giving up if we're putting stepped up basis as the highest priority? We're giving up the ability to move that land into the farm successor's name while we're living, which can have many benefits. Number one, we have talked about in other videos about how Minnesota does not have a gift tax. It does have a look back, but let's say, if I've got a $7 million estate and I want to gift that same $3 million of land, after 3 years, that land is not going to be part of my Minnesota taxable estate. Now I have a $4 million estate. I've just reduced my potential estate tax liability by potentially more than half. Or maybe I've eliminated it if I use my family farmland deduction. So we've taken that off the plate. capital gains tax is a tax that we control when we pay it because we're choosing to sell. An estate tax is a tax that we do not have control over when we pay it because we don't know when we're going to die. We don't know what the value is going to be when we die. And we do not know what the estate tax exemption is going to be when we die. So we're trading potential, control over not by prioritizing stepped up basis over gifting. We're also potentially eliminating a source of retirement income for the retiring farmer. We can sell that land. We can sell it at a discount on a contract for deed to our farming heir. Maybe we sell it for $5,000 an acre. Yes, again, in our example, I've got a basis of 3 and I'm selling it for 5, which means that everything in between is capital gains, so $2,000 an acre. But I could sell it on a contract for deed on an installment basis, which means that I will only pay tax as I receive those payments. The interest, of course, is going to be taxed as ordinary income, but the principal portion will be capital gains tax, which is a preferable tax rate to ordinary income, and I have my basis to apply to it again, right? So not every dollar is going to be taxed. So people get worried about that. Well, if I sell it, I'm going to have to pay capital gains. Well, what are you going to do if you hold on to it? Well, rent it out. I didn't realize that rent wasn't taxable. Okay, so you're paying tax either way, right? If we have those dollars coming to you this way, it's rental income. If they're coming this way, it's contract for deed income, right? There's certainly some considerations for the farming heir to consider if they're paying on contract for deed versus renting. For one, we cannot deduct the principal payments on the contract for deed. But again, these are considerations that if we just say stepped up basis is the most important, we're not even putting them in our toolbox. We're not looking at them, which means that we're selling ourselves short of what the farm succession plan could look like. Another reason, it'd be sure nice for you as the current generation of farmer to safeguard and see this farm get into the hands of the next generation. By its very nature, a will or a trust, a traditional estate plan, is not going to allow you to see that happen, at least while you're walking this earth, because it's not going to happen until after you're gone. So you do not get that satisfaction of knowing that everything is going the way it's supposed to. You think it's going to go the way it's supposed to. But I've had multiple instances. I had a farming heir that is a new client to me I say, well, it looks like you bought some land when mom or dad died. And they say, yeah, I had an option in the will. And I said, okay, good. That's something we would want to see. How did it go? Oh, well, my siblings were, putting a lot of pressure on me, saying that I was getting too good of a deal, or that it was written so long ago that it shouldn't apply anymore. He goes, so, they were trying to kind of guilt me out of it and saying that it shouldn't apply anymore. Not the first time I've heard that, or we find out that, there was a court case in Minnesota that said one of the farming heir would get a right to buy the farmland, and they had to pay a certain amount, within a certain period of time. And he and the seller worked out a deal where they would sell it on a contract for deed instead. And lo and behold, a beneficiary that has nothing to do with that arrangement came in and said, I don't like that. It says the trust says you have to pay it right away. You can't pay it over time. So therefore the option is invalid now. So you can see that if these options and right of first refusal are not crafted carefully, they could end up with an unintended result. But even when they are crafted well, and it is part of the overall estate plan, you still have the family dynamics, as my one client told me about, where they tried to invalidate it just on the basis that they didn't like it, right? They thought it went on too long, or that the will was too old and it shouldn't be valid anymore. So why leave some of these things to chance? And okay, great, we got stepped up basis, but now we have a family fight on our hands, or now we get to go air our entire family affairs up in the Supreme Court of the state of Minnesota. I don't think that's what mom and dad wanted, and maybe if they hadn't given such high consideration to stepped up basis, at least we would have had some other options to look at. So, stepped up basis is a great tool to use, and it's a very powerful tax incentive and advantage when we think that stepped up basis will be important. And it's only important when we sell. That is the only time it matters. So if we don't expect our farming heirs to sell, we could look at some other options, such as gifting, discounted contract for deed, but solely relying on stepped up basis and saying that should be the end all be all is leaving you with a plan that's not fully cooked and hasn't looked at all the options. What is one of the planning tools that I think is overlooked? Stepped up basis is an important tool, but it is not everything. Looking at gifting or other options can go along. So thanks for sitting through this one. As you can see, I'm in a new recording space today. I'm losing light, and I didn't want to mess with the other lights. So we're just going to go ahead and end it there. And hope you enjoyed the video. You can like and subscribe for more. Check out farmlawyer.com. You can also check out my law firm website, WagnerLegalMN.com.